the center of transitional justice discussions, not just at the domestic level here in South Africa, but also more broadly at the continental level. And I'm glad that we have John who is going to be talking to us on developments at the AU level. But also, I'm also very happy that we've got Commissioner Solomon Deso from the African Commission also telling us what has happened and what has been done at the African Commission level in respect of transitional justice. So the concept of transitional justice is very, very critical when it comes to the quest to secure remedies, to secure reparations, to secure compensation when you see when violations of human rights have taken place. So for us at the Center for Human Rights, we also have within the center a unit on business and human rights. And it also looks squarely at issues of the role of big business and multinational corporations in respect of human rights. What are the activities that multinational corporations and big business become involved in that have certain implications on the human rights of people, especially those who are in communities where development projects and also extractive activities relating to mineral resources are taking place. And you find that at the Center for Human Rights, our concern really is that we want to ensure corporate accountability and that the rights of communities, the vulnerable members of communities, are protected. And for us at the center, protection of vulnerable communities and those who are marginalized and voiceless is really our main focus. And this is why we have, I think, about 5 of our units within the center focus on protection of vulnerable communities. And so for us, this is really, really important. And we will continue to advance and fight for the rights of vulnerable groups in our communities, especially when it comes to how business and multinational corporations impact upon the rights of those people who are voiceless. And also, I just wanted to say that, we are also pleased in the sense that the center hosts the Secretariat of the African Coalition on Corporate Accountability, ACA. And I'm glad that Yolandi Meyer, who is the manager of that unit, will be presenting today. That ACA also focuses on issues of corporate accountability. On the continent, the Center for Human Rights is also a member of ACA. And therefore, I'm really pleased that, ACA is participating as well in this particular conference. So I just want to thank here, especially Hugo from Center for Human Rights, from the Center for Violence and Rehabilitation in South Africa, and who is really one of the people who came up with this idea for the webinar, and also to thank the director of CSVR, Anna Moyo, who has really supported this particular project, more particularly for her leadership when it comes to looking at issues of transitional justice on the continent. And I think, the idea for this webinar came as a result of the gap that we have noticed in transitional justice processes when it comes to reparations. Most of the focus is really on the role of government and maybe the security sector, without looking at the role of business and multinational corporations in violating human rights. And a lot of these companies have really never been held accountable. And a lot of them have worked with governments, autocratic governments, corrupt governments, and have perhaps maybe been co-opted or maybe captured the state in a way. I think in South Africa, we are reeling from the phenomenon of state capture. So if those companies have sort of captured the states in a way, in such a way that the states themselves do not even play a role of trying to protect, the rights of citizens, of vulnerable communities, of marginalized communities whose rights are violated in the name of development, and foreign direct investment, but also even more interestingly, local investment. And I think when it comes to foreign direct investments, we are looking at countries that are mainly companies that are coming from the global north, coming to invest in the global south. This has sort of been the biggest trend. So the question is, I think, and what we are hoping to get from this webinar is, what is the role of civil society in Africa in ensuring corporate accountability for human rights violations during transitions or after transitions? I think this is what we are hoping to get from the excellent panel that we have today, people who are really experts in the field. So once again, I want to wish everyone successful deliberations. I want to wish the panel excellent presentations. I would also want to wish the audience very fruitful discussions. There will be time to discuss and to interrogate, this presentation. So thank you very much, and I wish everybody a successful webinar. From wherever you are, it's a good morning, it's a good afternoon. Those who are attending and following this webinar, I wish you a very successful deliberations. And I think that I hope that after this webinar, we are going to take concrete actions, and perhaps also during the webinar itself, develop strategies of ensuring corporate accountability on our continent, so that we do not participate in the entrenchment of impunity in respect of the business world. We do not want the business world to do whatever they want without being held accountable. And I think perhaps locating this discussion as well in the context of the current discussions on the legally binding instrument being developed at the United Nations level, being drafted currently with the leadership, also interestingly, of South Africa and Ecuador. So thank you very much, colleagues, and I wish everybody a very good webinar. I would like to stop here so that we hear from the experts and from our partners from the CSVR. Thank you so much, moderator. I will now hand over to the director of CSVR to take us through this very, what promises to be a very interesting, productive, and perhaps even provocative webinar. Thank you very much.
Thank you, Lloyd, and good morning, everyone. Thank you for joining us on this exciting webinar looking at corporate accountability and transitional justice. On the African continent, we speak of almost 3 decades of transitional justice practice and implementation of transitional justice processes. And even when you track backwards, looking at some of the initial official transitional justice processes like the South African TRC process that sought to address the apartheid era violations, and then you jump to Sierra Leone that also sought to address the conflict-related gross human rights violations, you can identify the role of corporate of the corporate sector. For instance, in South Africa, a number of companies that also supported the apartheid era government and sort of contributed to the conflict that way. In Sierra Leone, you can also see the role of De Beers and other companies in fueling the conflict in Sierra Leone. However, we have seen transitional justice processes still being state-centric, not really probing the role of the corporate sector, the multinational corporations in fueling the conflict. And even some of our processes that look at nation building, reparations, and just working towards sustaining peace, those processes have really focused on broke governments, broke African governments that really cannot provide reparations for victims. We have seen some strides, however, in bringing the corporates into the conversation and highlighting some of their responsibility and some steps being made towards holding the corporate sector accountable for some of the violations. The case that Lloyd spoke about earlier, the Americana Massacre in South Africa, has brought in the corporate sector accountability to the equation. The silicosis case in South Africa that Hugo will speak about has also brought in the corporate accountability leg, which has been the missing link. The Killer case in DRC, although Anvil Mining Company was not held accountable, but their role was exposed in the killing, the torture, and removal of the Killer community from their land. And the decision by the African Commission already started us off in highlighting their role. However, some of our mechanisms and the rigidity around holding the corporate sector accountable perhaps continues to be a missing link in this conversation. However, today I do have a stellar cast of panelists who are experts in the corporate sector accountability and transitional justice, who will take us further, highlighting what has been done, what the African continent is doing in bringing in the conversation and the accountability of the private sector in transitional justice processes, holding them accountable for some of the violations, widespread and systematic violations that have been committed on the ground affecting African people, either through reparations, through truth-telling processes, through guarantees of non-recurrence, as well as through some of the reforms, some of the institutional reform processes and justice and accountability processes. I introduce my panelists just in name only, and then as they speak, as I call upon them to speak, they will then start with introducing themselves and their areas of expertise, and then go on to what each of their organizations and institutions are doing towards ensuring that the corporate sector is held accountable. I have Yolandi Meyer from the University of Pretoria. I have Dr. Hugo van der Merwe from the Center for the Study of Violence and Reconciliation. I have Mr. John Bodi Ikubaje from the African Union, the African Union Political Affairs and Peace and Security Department. And I have Solomon Deso, who is a commissioner at the African Commission on Human and People's Rights, who's also the chair of the working group on the extractives at the African Commission level. With that having said, I will now go to my panelists and I will ask them to start by introducing themselves. Mr. John Ikubache, over to you from the African Union. Please highlight some of the work that has been done by the African Union around this case. I know the African Union has undertaken some research around business and human rights, and the issue of corporate accountability has come up a lot in that research, and perhaps highlight also in terms of policymaking what the next steps are from the African Union level.
Thank you very much, Anna. And let me also thank the Center for Human Rights, University of Pretoria, and the CSBR for organizing this meeting, and also for inviting the African Union to be part of this discussion. As introduced by Anna, my name is Johnny Kubaje, and I am a senior political officer coordinating the African Union work on issues of human rights and transitional justice. Let me just start by a brief introduction. For some time now, the African Union Commission has been working in different areas, particularly on issues of human rights. One critical areas of our work is on development of policy instruments that relate to issues of transitional justice and also on human rights. And one of the policy that I believe many of you will be aware is the adoption of the African Union Transitional Justice Policy, which was adopted in 2019 February by the African Union Assembly. And we have been working in different areas to use the policy to also promote corporate accountability, both at the vertical and horizontal level. In addition to that, one of the policy that the African Union, one of the program that the African Union is currently working on is on business and human rights. And there are different things that we are currently working on in this area. The first one is the development and finalization of the draft African Union policy on business and human rights. And we are currently engaging the relevant policy making bodies of the African Union to finalize that policy for Africans to be able to use the policy. And we do believe that the policy will promote social corporate accountability. In addition to that, one of the work we have embarked upon in recent time at the African Union Commission Department of Political Affairs, Peace and Security, in conjunction with other AU organs working on issues of human rights, is a research that we are currently carrying out on the states of business and human rights in Africa. That research has been finalized now. We've had several consultations across the continent, and the research is looking very good, bringing out issues that are challenges, the progress that has been made with regard to national corporate social responsibility, national action plan on business and human rights, how our members state are faring on that. So this is some of the things that we are currently working on. In addition to that, and I think this will also be of interest to the participant, is that African Union is also working with the United Nations, the African Union Commission, together with the African Commission on Human and People's Rights. And we want to start this year what we refer to as the African Forum on Business and Human Rights. This is going to be the first edition of the African Forum on Business and Human Rights, which we do have in Asia and other continents. And by so doing, what we are trying to do is to actually deepen the culture of corporate accountability, in the private sector and also in the public sector. And so this is going to be another core area of our work that we have been working on in the areas of business and human rights. I think I will just stop at this end so that because of time and others also can introduce themselves. Thank you.
Thank you, Mr. Ikubache, for that introduction and also for highlighting what the African Union is doing in this area. I will now invite Dr. Yolandi Meyer to also introduce herself and also speak about some of the work that the center is doing in this area and highlight some of the challenges and some of the opportunities that exist in this area. Dr. Yolandi, over to you.
Good morning, everyone. So as I stated, I'm Dr. Yolandi Meyer. So I'm the new project manager for ACA, the African Coalition for Corporate Accountability. Basically, we are an African coalition of more than 100 countries, more than 100 members from several African countries. And the purpose is really to support communities and individuals whose human rights are adversely affected daily by the activities of corporations, both domestic and multinational. ACA was launched in 2013, and our members are also committed to rigorous advocacy to implement the UN guiding principles in a manner that also reflects the challenges of corporate accountability in Africa. So ACA is continuously working on several projects. We have our annual GA coming up in about 2 months. We will also have a conference, and we will be focusing on business and climate change on the continent and the effects of business activities on the continent as it also relates to the effects of climate change. We'll also be involved in the African Forum on Business and Human Rights that was mentioned, so the first edition. So we're very excited for that, and to also have our members involved in that. And then we're also involved in the UN process regarding the legally binding treaty, and also the Forum on Business and Human Rights at the UN level, making sure that we are also represented on the international level, and the negotiations that occur there, also representing our members there, and also the interests of the African continent. And then we also had several trainings earlier this year in several African regions on different issues regarding to corporate accountability in Africa. So those are just some of the activities that we have been involved in and that we are still involved in, but we are always collaborating with members and with partners on different projects related to corporate accountability on the continent, to make sure that we really do help our members and on the continent to regulate and to help regulate corporate activity, and to represent the voices of the communities as well. So I'm very excited to be part of this panel, and thank you very much for the organizers, and looking forward to be part of the discussions. Thank you.
Thank you, Dr. Yolandi. Dr. Hugo van der Merwe, over to you to also introduce yourself and some of the work that you have done, that CSVR has done in this area.
Thank you, Anna. And yeah, thanks very much for our collaborators, the Center for Human Rights and ACA, for joining us on this. I think just briefly in terms of myself, I do research on transitional justice mainly, and the CSVR kind of engages with corporate accountability very much through the transitional justice lens, which means that kind of how do we address the legacies of large-scale violence and atrocities in our societies. And this is something where there's various innovations, and there's developments both at national level and regional level to strengthen policy frameworks, to strengthen civil society engagement. And so we've seen vast developments in, I think if you look at truth commissions, how they've started engaging more effectively and more broadly in terms of the scope of their engagement, to look at human rights kind of through not just the civil and political, but also socioeconomic elements. And I think if we look back at the TRC in South Africa in 1996, where it had a very narrow mandate, and more recent cases that's expanded. The presentation I'm doing today is focusing more on kind of the recent research that we've done on the legal aim cases, the litigation that's been pursued and mainly by civil society, but also other actors against corporate interests, both criminal and civil claims. And I think that's an area where it's not an area of my expertise, and I have a co-author who's a bit more of a legal expert on this, where we've reviewed in 5 particular cases of litigation that I will share today. But before we get to that, let's do the other introductions. Thank you.
Thank you, Hugo. I don't see Commissioner Solomon Deso. Simpiwe, is Commissioner Solomon Deso here?
I'm still not in the room.
Still not in the room. Okay, we will introduce him when he joins us. Now going back to my panelists, let's start with you, Hugo, around the research that has been done by CSVR and highlighting some of the gaps that still exist, the innovation that has come up from national level litigation, from regional litigation, continental litigation, the mechanisms that have been put in place, some of the recommendations, policy recommendations, as well as some of the opportunities that exist for us to hold the corporate sector accountable for gross human rights violations in order to ensure that victims have access to reparation, but also to guarantee non-recurrence. What are some of the key issues that have come out of this research, highlighting some of the innovation, the recommendations, and just some of what exists and what still remains as gaps on the ground?
Okay, can you see my screen? I just wanted
not yet, Hugo. I think perhaps it's still coming. We can see you, but not, yes, it's coming. Great.
Okay. Okay, I think let me just start by acknowledging kind of my co-presenter who's in the audience, Kathy Ann Potgieter, who conducted most of the research towards that I'll be sharing today. And I think just to kind of share that this is a project of two collaborations. On the one hand, CSVR has been working with the University of St. Gallen with funding from the Swiss Network for International Studies. And then on the other hand, we've been working in collaboration with the Global Initiative for Justice and Truth and Reconciliation. And this has been kind of resulted in us looking at 5 case studies, and they're very diverse case studies of litigation in the context of transitions in 4 different countries, or 5 countries in fact. And what we're trying to see is kind of where can civil society really make an impact? What are the strategic issues that need to be considered when taking on litigation? Because it is a huge task. It's not a small project, as people would know. And the 5 cases, there's firstly kind of just, I'm going to run through them, but just with some lessons from each and then some comparative lessons. The Americana Massacre, and that's something where we're now, as Lloyd has mentioned, coming up on 10 years, where there was a massacre and other killings that happened, and that has still not been resolved. We're still struggling for reparations for victims. And essentially, we've got a process where kind of the company has largely controlled the reparations process itself. It was, rather than civil claims against the company, the civil claims were pursued against the state, and the company managed to, is engaged in various forms of reparations, but it doesn't call it that. It presents it as act of goodwill and charity for the victims, which is kind of, I think, critical to understand how that narrative is developed and how sometimes legal challenges can help frame a narrative of human rights instead of a narrative of charity by a company. And I think it's important to note that criminal charges were never instituted against the company, and it doesn't seem like they were even properly investigated. And I think it's important to note here also that we have political tensions within kind of civil society and within kind of the political sphere that has undermined broad support for the cause of victims. So we don't have an effective civil society mobilization, which in so many of the cases that I've mentioned that I'll come to is a critical factor. So we've got kind of legal, and we have criminal, civil, and company initiatives all happening at the same time in a very uncoordinated manner that leaves victims largely confused and unclear. The next case we looked at was the silicosis, which is kind of a disease that was found very wide scale on gold mines in South Africa. And that has, after decades or more than a decade of legal challenges, resulted in a huge settlement of in its 5 billion rand in South Africa, close to $500 million. And that is now busy, they're busy paying that out to the claimants. And it's important to notice the size of that settlement, which is 10 times the settlement that was, or 10 times the amount budgeted for the victims of apartheid through the TRC. So we're looking at a much bigger scale financial payment and reparations when we're looking at companies. Again, we've got a settlement between the company and the victims rather than a court judgment. So again, we see it's not, the company isn't found responsible. The company is able to frame the narrative as an act of generosity, not as a kind of a responsibility it has for an act of victimization. We also see that it's been a long battle to get here, and it's only feasible because our legal system in South Africa allowed for class action case to be pursued, where tens of thousands of victims can benefit from this one action. We also see that private law firms were a central role player in this process, and that is because it required millions and millions of rands of kind of legal investment to reach a settlement. And that kind of resources are just not available to civil society. We also see that challenges in representing victims is very problematic when the victims are scattered across, not just across different parts of South Africa, but across the region, where victims of silicosis also came from neighboring countries as migrant workers. So these challenges are kind of, I think, we need to have strategies that speak to this. This next case was the Sarawiwa versus Shell in Nigeria, where I think there was again a court kind of a claim, some claims that was pursued in Nigeria, but the main claim pursued in the US. And again, before it reached a court judgment, there's a settlement, an out-of-court settlement, which means again Shell escaped kind of a judgment about its liability. But there have been also various other cases pursued against Shell, and a campaign by activists that linked also to a more global awareness campaign, not just in Nigeria, but in other countries, that kind of that shaped a narrative about Shell's guilt. And there's, I think, the environmental movement more broadly that this kind of legal action tapped into, that bolstered kind of the local movement, the Ogoni people's movement, their claims. So it's not just a local advocacy; it's an international advocacy that needs to come together to give it effect. We also see that there's, on the one hand, monetary settlement that kind of can be quite substantial and alleviate the economic distress. But it doesn't amount to an acknowledgement, and we see repeated offences by oil companies. So there's not an effective kind of guarantee of non-repetition. We also see that continued advocacy of the families of the victims, backed by the movement of the Ogoni people, proved to be powerful. That it is kind of not just the legal case, but the advocacy and the media engagement that is critical. The next case is the London energy activities in Sudan, which is an ongoing case before the Swedish courts at the moment, because it was a Swedish company, London, that was involved in oil exploration in Sudan, and in parts of South Sudan now. Kind of, I think there's an overlap in the territory. This was before independence, and that kind of in their their arrangements with the government essentially led to the government removing large numbers of people from the territory that was being explored, resulting in numerous deaths and forced removals. And here, kind of, we see criminal charges being brought against the head of the company. And that is something I think that is exciting to kind of see, that there's actually possibility of criminal charges, not only civil claims. And I think the fact that criminal case can't be settled out of court. It's either not guilty or otherwise it does result in a judgment, which I think is important in both for the victims but also in ensuring non-repetition. And in this case, we saw that civil society documenting the abuses interviewing victims extensively on the ground, and then engaging in a strong media campaign, and that kind of combined with that, resulting in a kind of convincing a public prosecutor in Sweden to take up the case. The Killer Massacre, I think I've got other experts in the room who can talk more about that, but I think it's important to note, just to flag, this was a case where the African Commission for Human and People's Rights did make a very strong finding of not company responsibility, but the state responsibility to hold the company responsible. So it's kind of the Commission only has standing in relation, or only has, it can only make judgments against the state, not against individual companies. But it said that the DRC needs to take action against anvil mining. And ultimately, kind of although the Commission's findings can't be enforced, or there's kind of a long process of trying to pursue that, the finding itself is an important vindication of the victims' rights and the facts of what happened and the abuses that occurred. And the Commission, and in this case, the Commission, I think it's the range of different remedies provided to victims serves as an important example and precedent for other cases. But it's, again, I think, as in other cases, that we've got a decision of a legal body, but the implementation of it and the enforcement of it is a much longer challenge. I think I'm using up too much time already, so I think just to highlight some of the key lessons from these. I think firstly, not going to go through all of these, but to note that how we need to combine legal action with advocacy and media work. That legal action, and especially in countries where legal systems aren't fully respected, where the state doesn't kind of heed legal judgment sufficiently, or where the state in foreign jurisdictions respond to media awareness and public pressure, that a more integrated campaign is absolutely essential. We also need to kind of look at that the possibilities of universal jurisdiction are constantly shifting. We're seeing new kind of countries new possibilities opening up in various foreign countries, and especially, I think in both where in terms of when their headquarters are based there, but also more broadly in terms of universal jurisdiction reaching further and further. And I think just to kind of note that in none of the cases that we looked at did kind of the formal transitional justice process, such as a truth commission, provide specific recommendations or a foundation for this work. So essentially, the litigation happens independently, and often by different actors who weren't involved in transitional justice, but act in the corporate space. So it's important that we also look at opportunities to bring those together. Thank you.
Thank you, Dr. Hugo van der Merwe, for the extensive presentation around some of the challenges, the case studies, and also highlighting what the innovation that enabled the cases to go forward that you've highlighted, and also some of the missed opportunities and the gaps that still exist. I'm even thinking about the Malabo Protocol, which exists, but that particularly identifies corporate accountability as one of the international crimes that can be committed by the corporate sector on the African continent, taking into account some of the cases that you have highlighted and some of the historical ones where the corporate sector, the multinational corporations have been fingered and identified as fuelers or triggers and even sponsors of conflict in Africa. And with the Malabo Protocol not having gained enough signatures for its operationalization, another missed opportunity on the African continent in holding multinational corporations accountable for gross human rights violations on the continent, both as a crime, but also following litigation, either as civil suits also, as well as also through transitional justice processes where they can be held accountable to pay reparation, and where they can also contribute to nation building and some of the reforms that are much needed in a number of African countries. Without much further ado, I will now call upon Mr. John Ikubaje to also share about some of the research, particularly some of the innovations, some of the mechanisms that the research done by the African Union has found, and some of the recommendations that have been made from the policy and research front towards addressing some of these issues and moving the continent forward in recognizing and holding the multinational corporations and the corporate sector on the African continent accountable. John, over to you.
No, thank you very much, Anna. And once again, thank you for inviting the African Union to be part of this discussion. Before I narrow my presentation to the research that the African Union is currently finalizing, let me just first start from introduction angle to say that the concept of accountability is very broad, and I will not attempt to define its corporate accountability, but to just narrow it down to corporate answerability. And because we have so many definitions in the literatures on accountability, and there are also different typology with regard to accountability. But for the purpose of this, my presentation, what I will do is to narrow it down to the popular categorization or typology of accountability, which will also be linked to corporate accountability, and which is vertical accountability and horizontal accountability. And when I say vertical, I mean accountability from the citizens, private corporate entity to relevant institutions, and also government official, while the horizontal accountability measure is looking at accountability from the government institutions and different government entities to the citizens and also victims. But one thing that I want to emphasize before going to the main presentation is to emphasize that the victim is at the center of both these two types of accountability measures, and which is also very important in the work that we are doing, that I'm going to point to the two documents that I'll be referring to. So going from this premise, therefore, there are two normative instruments that the African Union has developed to promote accountability, both the horizontal and also vertical accountability. The first one is the African Union Transitional Justice Policy, and the second one is still an ongoing policy, which is the draft African Union Business and Human Rights Policy. But because Anna asked me to be precise on the issues of the work that we are doing on research on business and human rights, I will try to narrow this intervention first to that areas of business and human rights. But before I go into that, it is very important to indicate that the work we have been doing on transitional justice has really promoted the issues of both horizontal and vertical accountability, in the sense that we also emphasize the need for us to work very well with the civil society organization. And I think the African Union work experience with the civil society organization, particularly the CSVR and other organizations that has been working in the areas of transitional justice, has really helped us to mainstream, and when I say help us, I mean the African Union, in conceptualizing, the different policy that we have in place. They have really helped us to incorporate the element of accountability in the work that we do. And for example, if you look at the African Union Transitional Justice Policy, for example, you will see that one of the principles underpinning the policy is accountability, which is one of the African principles in the policy. So, aside from the provisions of the policy, one of the principles that's supposed to guide implementation of the AUTJP, which is the African Union Transitional Justice Policy, is accountability. And we have been working in different areas in member states to promote this. For example, we work with the Gambia Truth, Reconciliation and Reparation Commission, for example. We supported them. And we ensure that the issue of accountability take prominent in the works that they do, both in conceptualizing the Truth Reconciliation Commission and also in the implementation. And in doing this, we also work with the civil society organizations like CSVR that focus on the support to victims in the area of the psychosocial. In addition to emphasizing the principles of accountability, if you look, some of you that are familiar with the African Union Transitional Justice Policy, you will know that it has what we refer to as 11 indicative elements. And this element has critical elements that actually focus on promotion of corporate accountability. Because of time, I will just mention them. The first one of the elements is the justice and accountability, and which is all about investigation and prosecution of crimes perpetrated as a means of establishing accountability and giving judicial remedies to an acknowledgement of suffering of the victims. And so we have had experiences across the continent at the national level and different accountability mechanisms that the African Union and other regional economic community has promoted. Like, for example, you see the issues of the hybrid court for South Sudan that the African Union is currently pushing for to promote accountability through transitional justice in South Sudan. We have also seen the experience also in the Gambia and in Sierra Leone and some other things where we have seen corporate accountability and judicial accountability as a result of the Transitional Justice Program. Another one is the Truth Justice Commission. That is also a pillar or indicative element in the AU Transitional Justice Policy. This particular element is also meant to promote, accountability at the end of the day. The essence of establishment of the Truth Justice Commission is also to promote accountability. And the third element has to do with the reparative justice, or what we refer to as reparation. Without accountability, there can't be a comprehensive reparation. And so you see all these indicative elements in the AU Transitional Justice Policy as being critical, central to the implementation of AUTJP. All of them are meant to not only promote accountability, at the level of the perpetrators, but it is also meant to promote both corporate accountability and accountability on the part of the government, because perpetrators can either come from the government or from individuals or from private corporate entity. And so the elements, virtually all the elements that we have in the AU Transitional Justice Policy are meant to promote, accountability across board. And so these are some of the work that we have been doing in the areas of transitional justice policy, transitional justice to promote accountability, both corporate accountability and individuals' accountability. But having said that, now going to the second important point, which has to do with what Anna Moyo said. As many of you may be aware, currently the African Union has put in place a very robust program on business and human rights on the continent. And the way we have been going about it is first to have a normative framework that will guide the work that we are to be doing on business and human rights. And so the first thing we did was to come up with a draft policy. And the civil society play a critical role in this area as well, just like the development and implementation of transitional justice policy. So what we did was to engage a civil society practitioner who has been working in the areas of business and human rights. And so we have what we now call a draft policy on business and human rights. Where we are now is that the policy has gone through some level of consideration by the AU policymakers. We have what we call the Permanent Representative Subcommittee on Human Rights, Democracy and Governance. They've taken a look at the draft policy, and the next one now is to send it to the Executive Council, and the Executive Council will now refer it to the AU Specialized Technical Committee on Justice and Legal Affairs, that we now review the document and finalize it. And so in the draft policy, we have specific programs that it recognizes and highlights. One of the programs is in the areas of research. The second program is in the establishment of what we call the African Continental Forum on Business and Human Rights, which is going to be similar to that of the Asia experience at the UN Annual Business and Human Rights Forum. And that will give us the opportunity as African Union member states to share experiences and also to learn from one another on how to promote corporate accountability and how to deepen the culture of respect for human rights in corporate business environment. And we also have other things that, like for example, providing technical support to AU member states in the development of their National Action Plan on Business and Human Rights. So the entire program are so many, but I will just narrow it to the one that Anna said I should talk a little bit about, and which has to do with the research. But before I go into that research, the draft policy also has what we call indicative elements, and which is the section 2 of the policy. And under that indicative element, the one that actually promotes corporate accountability is referred to as the pillars. And one of the pillars, it has 3 pillars. The first pillar is the duty of the state to protect humans and people's rights. In other words, the policy recommend and provide that the state has responsibility for accountability to the citizens. Not only to the citizens, but also corporate entities. So the draft policy indicate that one of the pillars is the duty of the state to be accountable and also protect humans and people's rights in corporate environment. The second pillar is the business enterprise responsibilities to be accountable and also respect humans and people's rights. While the third element is access to effective remedies. As you all know, before there can be remedies, there must be accountability. So the draft AU Business and Human Rights Policy has these 3 pillars that are meant to promote corporate and individuals' accountability in the areas of human rights. And so we have been working with the civil society organization in the development and also in the implementation. Although the policy has not been adopted, but we have commenced implementation. One aspect of this implementation is the current research work that we are doing. The research work is look at the states of business and human rights on the continent. And the reason why we decided to do that is to have a baseline on where we are with regard to the work that we are starting at the African Union at the level of business and human rights. Although the UN has a UN guiding principles on business and human rights, and a lot of work is being done in that areas. But what we have been doing is also to support, to complement the work that the UN is doing on a UN guiding principle on business and human rights, to see how the African Union can work together and support, complement the UN in supporting its member states to promote the culture of respect for human rights in the private, in the business environment, and also to deepen the culture of corporate accountability on the continent. And so the research was carried out across the continent. One of the things that the research identify is that the Africa needs to take very seriously the implementations of the international treaties that they have acceded to, particularly the UN guiding principle on business and human rights. We realize that only 2 African Union member states has now developed what we refer to as the National Action Plan on Business and Human Rights, and that is Kenya and Uganda's. Others are still developing their own National Action Plan on Business and Human Rights, and we realize that a lot of work needs to be done. And so what the African Union is currently doing with some of the partners and civil society organizations is to provide technical support to some of our members states that are willing to develop their National Action Plan, to support them in developing their own National Action Plan. Another thing that we also realize is the what I will not call it political will this time around, but I would rather be diplomatic to say commitment of member states. We realize that yes, this agreement has been reached, and the National Action Plan, so many African Union members participated in the development of the document and adoption of the document, but the commitment is just not there. And so one of the reasons why we are developing the policy is to make sure that we come up with different initiatives that we encourage our member states to also support them, to develop their national action plan and also to be committed to it. Then another findings that we also get from the research work is that the African Continental Free Trade Area does provide an opportunity for us to be able, as African Union, to also promote the corporate accountability through the human rights lens. And so what we are currently doing now is also to work with the African Continental Free Trade Area Secretariat for us to embark on this African Continental Forum, the maiden edition. And we have been preparing towards that. And we are currently liaising and working with the government of Ghana. And hopefully by September, the maiden edition of this African Business and Human Rights Forum will happen in Ghana, and where all the private sectors will be brought together, the non-state actors, including the civil society organization, and also the government, and all relevant stakeholders working on business and human rights will be brought together for us to have ideas on what the states of a human rights situation and business is in the continent, and how we can all come together as stakeholders, to deepen the culture of respect for human rights in the corporate environment. Particularly the corporate accountability also come up very handy. And so another thing that the research also brought out, which is very clear, is the fact that on the continent, we do not have a continental platform where we bring researchers, stakeholders together, stakeholders together to share experiences among themselves, both at the level of the private sectors and also at the level of the government institutions. So this is going to be the first maiden edition, and the research also recommend that the African Forum on Business and Human Rights will play a critical role in this area, and that the civil society organization has critical role to play in time of advocacy and also providing technical assistance in the areas of their expertise. So these are some of the recommendations that the research has brought out. But having said that, there are other areas that the research also emphasizes, and one of them is the commitment or the need for the regional economic communities also to be involved in these particular areas, and also the reason why other researchers, institutions need to take further the work that we are doing. Although the African Union research has identified some specific areas, but the research also recommend that further investigations still need to be done, particularly institutions like the Human Rights Research Center, like the University of Pretoria, the Center for Human Rights, and others that have track record and have eminent researchers should take further the research, so that by the time we come up with the recommendations, we can look at how other researchers can also support the African unions to look at how to support member states to implement the recommendation that we have come forth. So this is where we are with regard to the work that we are doing in the areas of business and human rights. But more importantly, one of the things that we need to indicate is that we have realized that yes, at the African Union, we have come up with this policy, and we have come up with this idea of the research and recommendations, and we are also coming up with the Continental African Union, Continental Business and Human Rights. The African Union does not have all what it takes for it to push further and to make this initiative successful. We need the support of the African civil society organization. But the research also indicates that on the continent, African civil society organization and research institution need to prioritize the issues of business and human rights, to work more in that aspect, and for us to be able to see more partners that the African Union can work with. Like, for example, if you look at the work that the African Union is doing in the areas of transitional justice, we have so many individual experts, and we have so many corporate civil society organizations that are working on transitional justice. But the same thing cannot be said in the areas of business and human rights. And so what the research also recommend is that there is need for capacity building, not only for the AU member states, for them in the areas of business and human rights, the civil society environment space also. that capacity building is also needed in that areas so that all of us can galvanize together, both the African Union, the regional economic community, the civil society organization, for us to be able to deepen the culture of respect for human rights. And I believe that the issues of social corporate accountability will also be taken care of with this type of capacity building. So I think I will just stop at this end so that in a summary, this is what the African Union has been doing to promote corporate accountability and also to work with the civil society organization in the areas of business and human rights. Thank you.
Thank you. Thank you so much, John, for sharing that and for the open invitation for partnership and collaboration on this important work. The linkage of this study, the research and the work that the African Union is doing with the African Free Trade Area is also an interesting one that really needs to be taken up. And we're also excited about the platform that the African Union is setting up around issues of business and human rights, also making the strategic connections to issues of corporate accountability and linking also to the AUTJP, just also taking further the African Union Transitional Justice Policy, its provisions in extending also the issue of justice and accountability to also holding the multinational corporations accountable for gross human rights violations, the conflicts and the consequences of those conflicts and other occurrences that bring about gross human rights violations on the African continent. Thank you, John, again for highlighting those recommendations and also inviting civil society actors to also come on board and partner on this. I think this is a call for ACA. This is a call for research institutions in the room, the experts in the room in this area, the researchers to also probe further and partner with the African Union in order for us to really begin to shape and also bring in this expertise on the African continent, consolidating what has been done and building a community of practice around issues of corporate accountability and business and human rights on the African continent. Without much further ado, I will now invite Dr. Yolandi Meyer, who will speak about the legally binding treaty on corporate accountability and some of the United Nations instruments and soft law instruments that have been established around issues of corporate responsibility, corporate accountability, corporate answerability that John introduced in his presentation in how we can go forward using some of these instruments in holding the multinational corporations, the corporate sector accountable for gross human rights violations on the African continent. Dr. Yolandi, over to you.
Great, thank you very much, Anna. And yes, I think we're all very excited after hearing from John and from the African Union and the initiatives that you are planning. And I certainly can, I think, say on behalf of all of us that we would be available, our partners and members and all the experts to assist and work with the African Union towards achieving these goals as well. So that is a very exciting development. So today I was asked to speak a bit about the impact of the binding treaty and also the UN guiding principles on transitional justice, and also efforts to incorporate transitional justice measures to address violations of human rights that have occurred, especially in the past in difficult context as well. And I think the question that we really want to ask here is to what extent will the treaty and the UNGPs in its current form then be able to address these issues of transitional justice, and how can we ensure that these types of concerns are addressed in the instruments rather in future if it is not addressed adequately at present. So violations by non-state business enterprises are not traditionally always included in the formal definition of transitional justice, except for perhaps the corporate complicity element in rights violations of repressive regimes. So for example, in the Nuremberg industrialist trials that you might have heard of. And in the past few years, business and human rights and the transitional justice, those two elements have really developed as two separate disciplines, with one being perceived as being more forward-looking and the other one being perceived as focusing on the past, perhaps. And this situation doesn't really take into account the substantial involvement of business entities in human rights violations in repressive regimes and conflict situations, whether it be by collaborating with the state or financing activities that lead to egregious human rights abuses. However, many people have been advocating for the inclusion of these transitional justice measures in business and human rights legislation, and specifically in the legally binding instrument. If we just look at transitional justice a bit more, which many of you might already know, but just in terms of the United Nations definition, so it is the full range of processes and mechanisms associated with a society's attempt to come to terms with the legacy of large-scale past abuses in order to ensure accountability, serve justice, and achieve reconciliation. So some of the measures that state obviously use to implement these aims include things such as truth commissions, judicial prosecutions, institutional, legal, and social reforms in order to ensure that these past abuses do not also reoccur. And transitional justice also refers to the manner in which states then address human rights violations that occur during times of either armed conflict or civil unrest or repression. And it can also comprise then the formal and informal measures for obtaining justice and preventing reoccurrence. In terms of the reparations, then you can also distinguish between material and moral reparations, as some of you might also know, the former including more material goods, land, monetary compensation, and the latter including initiatives such as official apologies, acknowledgements, establishing memorial sites that Hugo mentioned in terms of some of those case studies like the Americana Massacre and some of the others. We've seen some of those types of reparations in those instances. And the reparations can then also be effected through more formal means, such as a court order, or more informal, such as a reparations policy, and also can be individual or collective in nature. And so it really is important that the legally binding instrument would provide for reparations of this nature, especially collective reparations, as business activity usually affects communities or groups of people, and we've seen this specifically on the continent. The instrument then should also preferably require states then to implement a national framework to provide remedy for groups such as these whose rights have been negatively affected directly or indirectly by corporate activity. And in the past, there really hasn't been much access through transitional justice process to address the actions and involvement of business actors in these kinds of human rights violations committed during times of civil unrest or conflict. And the traditional the transitional justice literature has also focused mainly on human rights violations that had been perpetrated by state and rebel groups or paramilitary groups. As one author actually stated, accountability for corporate complicity in authoritarian and civil conflict situations has really been referred to as the missing piece of the puzzle to pursue the full spectrum of justice and remedy for authoritarian and civil conflict periods. So attempts to reconcile these two disciplines in terms of business and human rights and transitional justice are really important and have only recently started taking shape, but mostly in the context of including the concept of corporate complicity into transitional justice frameworks. If we look at the legally binding instrument specifically, so at its first session, the Special Rapporteur remarked that an international legally binding instrument is a step in the right direction towards addressing any gaps or discord in the existing legal structure, while also addressing the lack of remedies available to victims. So it would seem that the negotiations surrounding the instruments would really be an ideal opportunity also to incorporate these transitional justice measures into a possibly binding instrument that can then finally reconcile these two disciplines. The instrument also has in its preamble as a goal the right of people to have equal access to justice and remedy in case of violations, and to facilitate and strengthen also mutual legal assistance and international cooperation with regards to mitigating human rights abuses. If we also look at the definition of the term victim in the instrument, it is quite wide, and it does provide for personal group of persons, individually or collectively, and it may also include immediate family members or dependents of the direct victim. There have also been, I think there was in previous comments, there was proposals by Cameroon and some states to have that provision read affected individuals and communities instead of victims. So there have been some proposals regarding the terminology there. And it also states that victims should be guaranteed the right to fair, adequate, effective, prompt, non-discriminatory and effective remedy in accordance with the instrument. So in terms of, if we just look at then, Article 5 provides for the protection of victims. There have also been recommendations here from some states, especially African states, to include then the term communities, so have it also focused on communities in terms of the victim, including them in that definition. And it also states that state parties will be required to take adequate and effective measures to guarantee a safe and enabling environment also for people to promote and defend human rights and the environment. So they are able to exercise those rights free from any threat, intimidation, violence, or insecurity. And then also a state duty to investigate human rights abuses under the instruments in accordance with law. And then Article 6 really deals also with the with prevention, which then discusses the due diligence measures. Although there seem to have been some pushback regarding this from certain states regarding the inclusion of due diligence measures. So you can clearly see which states are kind of against certain of these measures being more extensive, and which states would rather have more extensive measures in this article specifically. With regards to Article 7, access to remedy, is also quite an extensive article, and it places different responsibilities on the states then to provide courts and state-based non-judicial mechanisms with necessary competence to enable victims to have access to an effective remedy and access to justice. And the states then also have to ensure that their domestic laws facilitate access to information, including through international cooperation as set out in the instrument. And then also to provide effective legal assistance to victims throughout the legal process, and provide mechanisms then also for the enforcement of remedies. So I mentioned Article 12 and 13 also relate to the mutual legal assistance and the international cooperation. And this can be specifically important as well with transitional justice context, just because of the assistance that's needed between countries also when there has been issues of conflict or civil unrest with regards to evidence sharing and cooperation in terms of court cases, also where there has been, for example, a home state and a host state, to make sure that countries cooperate in terms of those processes and those investigations so that victims can get access to a remedy and make sure that they can get access to a judicial process or another process where they can have their voices also heard in terms of whether it's a formal or an informal process. But in that sense, states then also have to cooperate. Article 16 then deals specifically with implementation. So here it's interesting to see the mention of special attention that should be undertaken in the case of business activities in conflict-affected areas, including taking action to identify, prevent, and mitigate human rights-related risks of the business relationship. So here we really see the incorporation of business activities in conflict-affected areas, which could be in a transitional justice context as well. And it also states there that they have to assess and address the heightened risk of abuses in these kinds of instances, paying specific attention to gender-based violence, the use of child soldiers, worst form of child labor, and issues such as that. And in terms of then implementing the instrument, state parties have to address the specific impacts of business activities while giving attention to those facing heightened risk of human rights abuses in these contexts. So we really see, I guess, the extensive elements of the transitional justice framework, where we can see the access to remedy and the focus of victims in the legally binding instrument. And this is encouraging because as you'll see when I discuss the UN guiding principles, in the guiding principles, I don't think there's such an extensive focus on these kinds of elements, but I'll quickly go through that and then discuss in the end what the gaps are. So with regards to the guiding principles, I suppose we're all well known with the tripartite approach. The states have to protect human rights, meaning to regulate and respond to threats, and by business have to respect human rights, and both business and states have to ensure victims have access to effective remedies. In conflict-affected areas, states may also be unwilling or unable to protect human rights in terms of the guiding principles. Then the corporate responsibility becomes more important then to enforce these measures in these kinds of environments. So in terms of Principle 23 of the guiding principles, it states that businesses faced with this difficult situation in circumstances such as that should ensure that they do not exacerbate the situation. So this is the wording that is then used. Obviously, business then have to respect all human rights in all contexts and at all times, and therefore they should adopt policies, certain policies and procedures to mitigate the potential risks that are involved. The UNGP then also recognizes some, like I stated, some operational environments, so like conflict-affected areas that may increase the risk of enterprises being complicit in these human rights abuses. Businesses are then also advised to abide by IHL and to treat the responsibility to respect, which is normally then expressed as a social expectation. They should then treat it as a legal compliance issue, and they can then engage with external experts to ensure compliance with both human rights, international human rights, and IHL. So as we stated, the UNGPs, obviously they do have very extensive or reasonably extensive section on access to remedy, but they do not deal extensively with many of the transitional justice contexts, such as conflict-affected areas, which is also surprising because many human rights abuses by business occur in such environments and contexts. But Section 7, as we stated, does address supporting business respect for human rights in these kinds of situations. And it does also require the state to assist business to address and mitigate those risks. It also states that where the host state is perhaps unable to protect human rights through loss of control, the home state and even neighboring state may have a role to play in assisting businesses in this regard. And therefore, there are certain provisions in the UNGPs relating to these kinds of situations, conflict situations or civil unrest. And in a way, one can argue then that one can also argue that the UNGPs were not drafted with this specifically in mind, with the transitional justice context in mind, whereas we see the binding instrument has maybe gone a step further in that regard. There's also, as was stated by John, been limited domestic implementation of the UNGPs with regards to the national action plans, especially I think with regards to transitional justice context, but that's something that hopefully will change in future, and much more work will be done to also assist states with that. So the UN has really made great strides in the past few decades by constructing this comprehensive framework relating to business and human rights, and it has provided guidelines for business in this regard. But most people can agree that the UNGPs are a helpful resource to determine the expected standards of corporate behavior and to also set certain expectations for their activity. But they have proven to be quite lacking when it comes to matters of enforcement and implementation, as I think we can all agree, even especially on the continent, with limited domestic incorporation. And also with regards to environments where transitional justice measures are required to address former human rights violations. So with a limited focus on restitution and victims' rights and other important elements, with regards to the UNGPs, the binding instrument, on the other hand, seems to be dealing a bit more comprehensively with these issues. And it's really encouraging also to see the instrument focusing on issues such as victim assistance and access to remedy and restitution. But even though it has the potential to address these issues and incorporate measures to implement and enforce them, there has been major pushback from certain states in the instrument negotiations when trying to incorporate stronger language to address these concerns. That would really give the transitional justice agenda a stronger platform within the instrument and incorporate those measures. So I think some things that could be done perhaps in this context is also to obviously strengthen the implementation and enforcement of the instruments, and also in relation to the guiding principles, and ensure that these transitional measures are really included, and to require states to provide their mechanisms at a domestic level to provide reparations and redress, and so that it's very specific so that it can actually be implemented in a practical sense, because especially in terms of international instruments, often you have certain standards being set out and then it's left up to the states. But then in terms of that, it's almost like you hit a wall there, and it has to be incorporated then on a domestic and a regional level. It's also important to incorporate the access to justice, whether formal or informal means, access to remedy and redress, applicable to all business enterprises, and the establishment also of monitoring and compliance bodies. And I think extraterritorial accountability into the instrument would also very much assist this process. And it may even be useful to also have separate provisions or standards specifically dealing with the responsibility of business in conflict-affected areas and transitional justice contexts, considering the fact that a lot of the instruments are not drafted with that primary focus, but to really bring in an element or that element of transitional justice focus into the instrument and into any potential instrument in the future. So this is really just, I've gone through kind of the instruments and seen a few gaps, but I am encouraged by the progress that's being made in terms of the instruments. And obviously it's an ongoing process with treaty negotiations, and it's not finished or finalized by any means. But looking at the negotiations at that level, at the UN level, with regards to the instrument, one can really see that there are certain states that are trying to push for stronger language, and a lot of African states that are trying to push for stronger language in terms of victim rights and restitution and reparations. And there is some pushback then by other states. So it seems to be a little bit of a fight also to incorporate certain elements depending on the region and what the need is, and what certain states find also more important in terms of what they experience in their environments. So I'm really hoping that with the involvement of civil society and with the involvement of different actors, we can help to push this agenda of also transitional justice at the international level, so that these measures are incorporated to ensure that that the victims really have a voice in that sense, and so that these measures are incorporated in the instrument, and when they are incorporated, that it is in such a way that it can be implemented and enforced on the domestic and the regional level to actually make a lasting difference. Thank you.
Thank you, Dr. Yolandi, for your presentation, highlighting again some of the principles at United Nations level, and also just expounding again on the issue of a binding treaty in this area. This ties in with one question that has actually been asked by one of the participants around the binding treaties, the binding policy imperatives around this issue of business and human rights, but also on state accountability. We will now, without much further ado, open the space for questions and answers. I see we have 2 questions already. I will read out the questions for our panelists to respond to them. I now extend an invitation to our participants to put their questions, their comments on the question and answer. I see some are being put on the chat box. We will read them as well. So any questions, any comments, any additions, any insights that you may have on the presentations that have been made, or any experiential information that you may have from the work that you are doing on the ground, please do share on the question and answer or on the chat box. I will take up the 2 questions that have been asked so far. The one question was asked by Obed. Obed says, thanks, John, for your presentation. The policy is a very interesting idea. To what extent will this policy on business and human rights become something binding that states and business actors can respect? I know the UN guiding principles are not binding, and that is a big challenge for enforcement. Would the policy be different from the guiding principles that are not binding? There was also a question on the question and answer. The question goes, to what extent has the African Transitional Justice been implemented to the African Union member states? I will direct these 2 questions to John. John, over to you. I know you will have the answer also to the one on the extent to which the African Transitional Justice policy has been implemented in the African Union member states, and also the one around the policy on business and human rights that the African Union is looking into developing.
No, thank you very much, Anna. And let me also thank Obed and the other participant that asked questions. Let me start with the one of the business and human rights policy, whether it is going to be binding. During the consultation that we had on the development of the draft African Union business and human rights policy, it was a hot debate. because what we did was to bring about 70 civil society organizations, government official, national human rights institutions together, and private sectors together in Addis Ababa. And there were the house, those that we consulted were divided into two. One says that we should go with the policy, which is a soft law. Then the second school of thought says, no, what we should do, that the United Nations Guiding Principle seems not to be working well on the continent, and instead that we should go for a binding instrument, a legal framework. But having this school of thought, we then agreed to make these recommendations. But the agreement by the policymakers that the member state was that no, we should take it step by step and first come up with the policy, which is the soft law first, and later on we might be thinking of the binding instrument. So what we currently have, Obert, is that the policy is a soft law. It's not a binding document, just like the African Union Transitional Justice Policy. But the plan is that after we have this policy, what some stakeholders are saying is that we should go ahead and develop a law, an instrument, framework that will be binding, and by so doing that it will compel, directly or indirectly compel our member states to implement the document. So that is where we are with regards to the issues of binding or no binding of the draft AU policy. But those are some of the, and those are the reasons why the role of the civil society is also very fundamental. We know that the civil society does have interaction and engagement with our member states. That document, the draft policy for now, is going to be finalized by the AU Specialized Technical Committee on Justice and Legal Affairs, which are made up of all the AU members' legal technical experts. They are the one that is going to finalize that document. And so if our civil society can do a very good advocacy to reach out to member states to say that the current policy that is being developed and finalized at the level of the African Union should be made a binding document. So we can then see member states coming forward to say, okay, this document should be a binding document. So we believe that the civil society has critical role to play in also helping us to advocate that the document should be made a binding document. So that is where we are now. But for the policy as it is now, it is not a binding document. It is just a soft law like the African Union Transitional Justice Policy. Now, moving to the second question, what is the state of the implementation of the African Union Transitional Justice Policy? I think we are very happy with regard to the implementation so far. What we did is to avoid the AU Transitional Justice Policy being like other policy that just end up in the shelf. What we did, immediately after the adoption of the policy, we developed what we call a roadmap for implementation of the AU TJP. And we also work together. The moderator, Anna, was also one of the stakeholders that contributed. I mean, CSVR was one of the stakeholders that contributed to the development of that roadmap of implementation. And as a result of this, we have been able to mobilize resources outside of the AU circles for us to be able to implement. And as you may be aware, there are different programs in there. We have things like research, technical support to member states. And so what we have been doing, for example, together with CSVR, 2 weeks ago, we were in Central African Republic, where we have been invited to provide technical support to the Central African Republic Truth and Reconciliation Commission. So our team technical expert, together with the staff of CSVR, AU staff, and other technical experts on transitional justice, we were there to make recommendation and to provide technical support for them. And so we will be going there, to make sure that the recommendation and their requests are met in time of technical assistance. In addition to that, we have also been providing technical assistance to DRC. We were also at DRC, where we are currently providing some technical assistance to DRC. We are also in other countries. In Ethiopia, for example, where we are currently there trying to do a secondment of our transitional justice advisor using the African Union Transitional Justice Policy to support the Ethiopia. One interesting thing that we have been doing, and we have been doing this together with the CSVR, is the translation of the African Union Transitional Justice into African local languages. We have translated the document into Amharic, which is the official language of the Ethiopia. And the reason for this is to make sure that we have popular participation in the transitional justice process here in Ethiopia. We have also translated the policy into Swahili so that it can also be used in some of the countries that are on the continent where they are speaking Amharic. We are translating it into Lingala, and we have also translated it into Lesotho. And so these are some of the things that we are trying to do to popularize the document so that it can be available for vast majority of citizens where countries are implementing one form of transitional justice mechanism and or the other. So we have been doing a lot of work, particularly providing technical assistance. And what we have even been witnessing as a result of this is that member states are now beginning to reach out to us, to provide support for them. And one angle that I want to bring in this area, like for example, what we have been doing in areas where we do not have technical expertise. For example, in the area of psychosocial support, we do not have technical expert in these areas as African Union. And so we leverage on the technical capacity of organizations like the CSVR to provide psychosocial support in the areas of transitional justice to our member state. And so, for example, we have CSVR now working with the African Union and has seconded technical experts to the Gambia, and we are also planning to do same to Ethiopia and also to other countries that are currently implementing, like South Sudan and Sudan, currently implementing their transitional justice. So in a nutshell, I think this is what we have been trying to do in our own little way. Although we have resources challenge, but in our own little way, we have been there for some of our member states to see that the African Union transitional justice policy is operationalized in the context of their own transitional justice program. Thank you.
Thank you. Thank you so much, John, for answering those questions so extensively. I have another question from Alan Gary. Gary says, thank you to the panelists for your very insightful presentations. Could the panelists please speak to avenues for criminal accountability for foreign corporations not registered in African countries that they operate or are operating under subsidiaries for illicit activities and violations of human rights? I'll direct this question to Hugo. Dr. Hugo van der Merwe, over to you.
Thank you, Anna. I think just to say that this is something that is fairly new being explored. I think in terms of and particularly the question of, well, who pursues these cases? Because it does not appear that taking the lead in pursuing such cases. So it is essentially up to civil society to pursue cases against corporate executives. And the question is also, well, where can they be pursued? And on the one hand, where they're headquartered, but it's also, I think, a question of how to convince governments in those countries that they are the appropriate jurisdiction. I think in the Anvil case, it was also in civil society tried to pursue the case against Anvil both in the Canadian courts and in Australia. But those in the prosecutors in those countries basically it seemed deferred to the DRC as the appropriate jurisdiction, and the DRC in the court case went nowhere. So I think this is, and I think that I can't talk about the legal issues because I think there's a certain sense that the legal, I don't know what the legal challenges are about the individual responsibilities and how one proves individual responsibility for such cases. I think this is something that is quite new. And I think also maybe to highlight in the Kenya post-election violence, the ICC did initially do some investigation. There was one corporate actor involved who the ICC looked at initially, but that also did not continue and result in an actual case being pursued. So I think this is kind of it's a new area, and I think it's an exciting area that I think we really need to pursue actively, both in terms of the legal framing, but also the politics of pursuing such cases.
Thank you, Hugo. And I mean, I'm also trying also to think of the Killer case, for instance, where the Anvil Mining Company was an Australian company, but when community members through advocacy tried to reach out to the Australian government to pursue litigation in Australia, it also came out that the organization had moved and now it had its headquarters in Canada. So some of the hurdles that African litigants have to go through when trying to hold international organizations accountable in the countries where they are headquartered or registered. In Africa, definitely, it's almost impossible to hold them accountable through national courts when they are not registered in the country, are merely operating in the country. But where they do have a registration and an office and they have presence in the country, it's easy to do so. But in the event that they are literally just operating without any registration in the country, it becomes a bit difficult. The case also, the Kulumani case, when they went to New York to try and hold one multinational corporation responsible, the issue of jurisdiction came up in civil litigation, where, for instance, the government, the host government said there's no jurisdiction because, again, the crime was not committed in that host country, although a private company may be registered in the host country. But for an African organization, for an African litigant to pursue civil litigation in that country, there are many hurdles that civil society organizations and victim groups encounter trying to hold the host country of the organization accountable. Issues of jurisdiction come up a lot, particularly when the laws of the land in Africa are not the same as the laws of the land, or what is considered a crime in Africa is not considered a crime in the host country, in the country where the organization or the multinational corporation is registered in. I don't see any other question, but there is a comment here by Jafet Bwire Manyama. Jafet says, this course is very important. I advise that it be one of the advanced human rights courses at the Center for Human Rights at UP through its good governance courses. I definitely concur with what Jafet is proposing. I think we are at the initial stages of exploring and consolidating what corporate accountability looks like from transitional justice, from a business and human rights perspective. And with what ACA is doing, the research that has been done by the African Union, by CSVR, and other research organizations, by environmental rights organizations on the African continent, I think we have enough to really start consolidating some of these discussions today into an advanced human rights course, probing further how this looks like in practice, but also looking at the school of thought, the paradigms, and also the policy recommendations, as well as practice-related interventions that will start us off on really concretizing and creating specific pillars around corporate accountability on the African continent, vis-a-vis gross human rights violations that are committed by the multinational corporations, as well as ensuring that victims are not left outside of the reparations that they may access through holding the corporate sector accountable for some of these atrocities that are committed on the African continent, and ensuring that a number of transitional justice processes and initiatives are advanced through holding the corporate sector accountable for some of these. I think in rounding off, on behalf of ACA, CSVR, and other host organizations of this important panel and discussion on corporate accountability and transitional justice, I would like to thank all our panelists for the stellar presentations that they have made today through this webinar, and also for the recommendations that have been made, concrete recommendations that take us forward in terms of how do we build upon this and how do we consolidate, what are the entry points, and how do we all come together and ensure that there is a community of practice around issues of corporate accountability and transitional justice, building upon what already exists, some of the attempts on the ground by civil society actors, by the African Union, by such institutions like ACA that have got membership of a number of organizations on the African continent working on these issues, as well as some of the research institutions that are here today and who have shared some of the work that they are doing on the research front. How do we bring everything together? I think there is a lot that has come up today. I will not do a disservice by trying to summarize that, but I also like to extend thanks and gratitude to all our participants for joining us today, but also for some of the questions and recommendations and insights that they have also shared that take us forward and move us forward towards consolidating and concretizing a particular practice and focus area on this important work on the African continent. Thank you again to everyone for participating in this forum, in this webinar, and also for sharing some of the most important recommendations that really give us a lot of food for thought in terms of how do we take this forward, who do we need to partner with, but also how do we engage in some of the existing mechanisms, processes, opportunities that exist on the ground. And also this was also an important networking session as well with a number of civil society organizations that may not have known what is happening at the African Union level, what is happening at ACA, but most importantly have found linkages and ways of amplifying and enhancing their work and making the rightful linkages to some of what is happening continentally with what is happening locally or at national level. Thank you again, everyone, again for your time in participating in this webinar and also for sharing some of the insights and recommendations through this webinar. Thank you so much to our organizers. Thank you so much to the hosts for this important webinar. We hope to take this forward one way or the other and make some consistent engagements around this area and share information around some of the key points and key recommendations that have been made here. I think the recording will be made available and we will share this with the wider audience. And to all participants that have also joined via Facebook and other platforms like LinkedIn, thank you again for everyone who's been live streaming as well from various social media platforms. Thank you again, everyone, and we wish everyone a lovely afternoon going forward. Thank you.
Thank you, Anna.
Thanks, everyone.
Thanks, everyone. Have a lovely day. Bye.